Okay, so today's lecture is going to focus on what we're going to start with is something called intellectual torts. And last week we spent some time on basically the burdens of proof and criminal law versus civil law. And today, when we talk about civil law, you always have to keep in mind the burden of proof. So who can tell me the burden of proof in a civil matter?
In civil law, you need to prove less than a reasonable doubt, about 50%. Yeah, right.
Preponderance of the evidence, so it's a little more than half. And that's so if you have a scale when you're doing a civil case, it's just a little more than slightly higher than the 50% mark. So whenever we talk about anything civil, not criminal, that's kind of the burden of proof that you have. We're going to talk more about elements, and you're going to kind of see now certain themes start to take shape and repeat themselves. So whenever I talk about elements, I'm talking about the definitions of certain things. So the first thing we're going to talk about today when we talk about intentional torts there are intentional torts. When you hear the word tort, what do you think of? It's not a cake, so don't even say that. It might not be a word that you've actually associated with the law. And basically, torts are certain types of negligence actions. So automobile accidents are considered torts, professional malpractice, product liability, those are all torts. And some of them have an intentional component. The three basic principles that, and this is also still stuff that's listening, not a writing down moment. The three basic principle when we talk about intentional torts are essentially compensation. So you want to compensate the person who sustained harm or injury. You want to make sure that the person who caused that that injury is the person that actually pays. So you don't want somebody who had nothing to do with the incident to pay. It's the person who's responsible for it. That's the one that have to pay. And you also want to prevent future harm and losses from happening. So in some of the cases, one case in particular that we're going to talk about today, you're going to see that concept where you want to prevent future harm or losses. So sometimes you have certain allocations of funds or punitive damages because you want the person who caused that intentional harm not to do it again. Whenever we talk about negligence, this is now a write it down moment. The elements in negligence, there's always 5. And we're going to talk about that a couple of times today. I'm going to go through it in detail now and then a little bit later in the class. So whenever we talk about negligence or torts, there's 5 elements. There must be those 5 elements in order to be successful on a lawsuit. So there's duty. I'm going to actually put it in your chat. It's just simple words, but I do want you to know it. Okay. Okay, so we have duty, breach, proximate cause, actual cause, and damages. So whenever there's a negligence action, those are the 5 elements that must be there in order for somebody to be successful on that case. So what are those things? Now this, I'm hoping that you've read for today, and so these things should ring a bell. When we talk about duty, duty is a relationship. It is a relationship between 2 people, and you always have to ask, is there a duty from one to the other that they should kind of be aware of, or that makes one person responsible for the actions of another? So there are certain duties that the law recognizes between people. So if I'm driving on a road, right, I'm behind the wheel of a car, I have a duty to everybody else on the road to follow the speed limit. I have a duty not to run over pedestrians. I have a duty to be safe in how I'm actually driving my car. Duty can also be in a lot of other different scenarios. So not just with cars. If you're driving, that's one way. If I'm teaching an elementary school class, I'm responsible for those children. I, as a teacher, have a responsibility to those minor kids to protect them, to make sure that nothing happens to them. Remember last week when I gave the example of the EpiPen and whether or not I'm going to save that person or not? I asked you, if there's any minors involved in that class, in your class. And the reason for that is my relationship or the duty I would owe a minor is different than the duty I would owe to an adult. There's also certain duties between places of hospitality. So a hotel has a duty to its the people that are in their facility. A bus driver, public transportation, they also have a duty to their passengers. So there's a lot of different types of duties. And so that's one of the things that the court or the law looks at before ascertaining whether or not there's a liability factor. The next one is breach. Was that duty that one person owed to the other breached? Was it broken? Was there a problem with it? The third, I'm actually going to start with the fourth one, which is actual cause. Did that breach of the duty cause an incident of some sort, right? So me not stabbing you with the EpiPen and saving your life that we spoke about last week, did that cause harm? Were you damaged in any way? So was it an incident that happened? If you bring it to a car accident, right? So I owe a duty to the other cars to kind of be following the speed limit and all that good stuff. If I go past the speed limit, I'm breaching my duty to be aware and a responsible driver. If I get into an accident, that's the actual cause of the incident that we're talking about. The actual cause is the incident itself. Proximate cause is a more difficult concept sometimes to understand. And the proximate cause is the but for. There's a specific case we're going to talk about today that really highlights the proximate cause. And it's about, you know, had I not been doing what I was supposed to be doing, would this incident have happened? Another main aspect of it is foreseeability. Was this accident foreseeable based on the circumstances that happened? And the last element is damages. Was there any harm incurred? I talked actually to my Monday night class about something that happened in real life. I went on Monday and I had to see my parents. My parents are older, obviously. And so in front of their driveway, when I parked and I was going into the house, there was a lot of ice and it was so slippery. And my neighbor had seen me trying to get out of the house with my kid and he was helping me so I could like kind of walk. And he mentioned that he slipped and fell. So that automatically in my brain, slip and fall, that's not good. There's liability, there's, injuries that can happen, lawsuits, all that good stuff. So I called my parents and I said, you have to, remove the ice. Now, although it had snowed, the day before, wherever it was, and there was a likelihood of snow coming the next day, it's still a responsibility for homeowners to remove the snow and ice in front of their homes, right? Because what's going to happen if somebody slips and falls in front of your house? Apply the elements I just spoke about and tell me what happens. Can that person sue based on the elements that I gave you?
Yes.
Give it to me one element at a time, if you can. Is there a duty of the homeowner to make sure the sidewalk in front of their house is clean?
Yes.
Yes.
That's right. That's something that, it's public streets. So then if it's in front of your home, it's your obligation to clean it. So there's a duty. If somebody does not remove the ice in front of their home, did they breach that duty?
Yeah.
Yes.
Yes.
And if
Breaching is like,
go ahead.
sorry, because I just want to be clear, before we move on.
Yeah.
Breaching, when you talk about breaching, you're talking about like breaking a rule
Yep.
or like,
Yep. Breaking that duty, basically breaking that duty, not doing what you're supposed to do.
okay, thank you.
You're welcome. So actual cause, if somebody slipped and they got hurt, is there actual damage? Is there an actual cause? Did an incident occur?
Yes.
Had the people actually cleaned their house, would that person have fallen?
No.
No.
And if the person broke their leg, is there damages?
Yes.
So then there's a lawsuit. There's a potential lawsuit right there. Somebody wrote, don't you have 3 hours after a storm to be considered in breach? I don't know if there's an actual time limit on it. It has to be a reasonable period of time. So it's not a specific like hours because that's hard to gauge, and it also depends on the area that you're in, but there's a reasonable period of time. When you look around and the entire block has cleaned the snow and except for one house, that's a problem. We're going to also talk about the reasonable time a little bit later. There's a case actually that we're going to discuss today that also highlights that. So I kind of just went over these 5 elements, but as you saw from reading the material for today, the cases we are going to discuss are going to highlight these legal principles. Let me see here.
Could you go a little more in depth on proximate cause? I don't think
There's
I.
proximate cause is a very difficult concept, but there's a case today that we're going to talk about, Paul's Graph versus Long Island Railroad, and that case really highlights or really explains well the proximate cause. When we spent an entire day on it or more in law school, proximate cause. So again, I recognize this is a 100 level class, an undergraduate institution, but think of it as the but for, but-for, like but for somebody not doing something, would it have happened? It's kind of like you're replacing facts. And the case also
Okay.
that we're going to talk about today is foreseeability. Was it foreseeable based on the events that this would happen? So
Okay,
those
no,
are
that
the
makes
two ways.
sense.
Okay.
Yeah, okay, thank you.
You're welcome. So, okay, so the first case we're going to talk about today is Philip Morris versus Williams. Who would like to tell us about that case?
It was about Big Tobacco versus a family, Williams.
Great. Can you tell us a little more?
They found that Williams had some responsibility, but Morris, because of the advertisement, he got a big case with punitive damages, and he basically made a lot of money. The family.
Well, he was dead, right? Yeah,
Yeah,
the
the
family.
family made a lot of money, and they felt that it wasn't excessive, the penalty, because it was a future deterrent.
Right. Now, you actually said a very important word, and you said punitive damages. What are punitive damages? Do you know?
Yeah,
If you had to give me another word for punitive, like a synonym for it.
punishment.
Punishment, exactly. Perfect. So this case actually is what I was talking about before. When you have you had somebody that smoked. They died as a result of smoking. And this was a relatively, like, it's not an old case. I think it's like from the early 2000s. He smoked. He died as a result of smoking cigarettes. And so Philip Morris was sued. And the actual individual was awarded, the family, the wife, was awarded, I think, like $821,000 in damages based on the lifespan, based on his life. And then after that, the court, hold on, I have to yell at my kids. I hate kids. So when you have that, you also have the award of, it was like $79 million that the court awarded. And why was that award in place? Because the court set that as punitive damages. It was meant to punish other companies that sold cigarettes from what they were doing. If we were in class, I would ask, but I'm going to ask it here, although none of you have the video on today, so I don't see anybody except a bunch of names. Does anybody here smoke cigarettes?
No.
Thank you for showing yourselves. I appreciate it. If anybody does smoke cigarettes and you can volunteer to show me your cigarette packet, I can illustrate. Thank you for all the videos, because now it makes me feel like I'm not talking to myself. It's greatly appreciated. No cigarettes? Okay. That's good. I'm glad that nobody's smoking cigarettes, actually. So that's a plus. So back in the day, cigarettes, they had their box, whatever. And I remember this because I used to work in a deli that my dad and my uncle owned a long time ago, and we'd sell cigarettes. Back then, huh?
I can show you my brother's pack if you want.
Oh, yes, please. That would be
hold on.
great. Thank you.
Oh,
And I will continue. Back then, the packet of cigarettes, Marlboro, was like $2.25. And I think this was before this case came out. That tells you a little bit about how old I am. And after this case, I'm waiting for I think it was Dia who said that they were going to show their brother's cigarette packet. I want you to see what the packaging now on cigarette boxes look like, because that is a direct result of this particular case.
Are you talking about the Surgeon General's warning?
That's huge. It's not just in small, tiny writing. It's now, it is big, bold, huge, gigantic letters that says this product may kill you. If you're pregnant and you're smoking, you're gonna, injure yourself. And I mean, it has all these excessive warnings, and it is written in just such big letters. Why? Because it is meant to serve as a warning. Because in this case, the argument was that the consumer did not know how bad this product was. If they had known how bad this product was, they would not have smoked and they would not have died. So that was a big thing in that particular case. I don't know, again, where you are in life as far as, your age. I remember advertisings on commercials for cigarettes. The Camel, that was like a big thing. There's a lot of promotional stuff to induce people to smoke. My dad used to smoke 2 packets of cigarettes a day, 2 boxes of cigarettes a day. It was Marlboro, the red or the gold, I don't remember.
Same with my
But
dad.
thank you. And it had like these like not stickers, like if you on the box of the cigarettes, if you remove the side panel, it was like a rewards program. We had so much Marlboro products. He had like winter jackets, we had t-shirts, we had a canoe. We had a canoe with Marlboro on the side. Now, luckily, my dad hasn't smoked for, I don't know, 20, 25 years or something, but that's how much he smoked. That's the product. Did the person that was going to go get the box come back?
Yeah, I'm here.
Oh, can you show it to us?
Oh yeah, my bad.
I'm stalling.
Okay.
All right, let me see. Wait, that doesn't have anything. Where'd you get this from?
My brothers.
Yeah.
Yeah. What do you mean? I'm
Do you
good.
see, does it say anything about the Surgeon General's warning and how this product can kill you? Is this from overseas?
No.
No. Does it have it?
Yeah, oh, maybe it has another pack. 1 second.
Yeah. I mean, you don't have to go nuts. Usually, like, I mean, it is in huge, huge letters, like huge. You can't miss it.
I know I think it's Italy, they have like pictures of like decayed and like rotted lungs.
Yeah, I mean, they are exactly like they are now like, because what's going to happen is they don't want to be sued again. This was $79 million for one person. In excess.
I don't see it. It has like this like general warning though.
Yeah, Europeans smoke every day. Okay, I mean, I don't know if it's because it's on this thing, but all right. Well, thank you for trying. But in conclusion, I'm glad that none of you guys smoke. This case was a prominent case in the field of tobacco. They don't advertise for cigarettes anymore. There's no more commercials. A lot of this case actually changed all that because it was supposed to give a responsibility to the tobacco companies not to kind of try to get people to smoke because of also the addictive habits and stuff. So I know that David was the one that actually told us about this case, and I don't remember if I told you guys this last class, so I'm going to say it again as fair warning. So I don't assign specific assignments, right? And I don't assign people to read certain things. So I'm always going to ask for volunteers on the cases that are scheduled for the day. If there's a case that comes up and nobody volunteers for it because nobody read, I'm not going to tell you what that case is about, and I'm going to put it on the exam. So you need to read. If you're in study groups, divide the cases up, but you should be reading because that's the only thing I give you. So make sure to read, especially the cases. I watered this syllabus down, so I'm only telling you the things that you need to know. So just make sure you kind of stay up on top of that.
I'm still waiting on the book.
I'm sure can't you get an electronic copy or something?
I can't. I'm waiting for my next paycheck to get the book.
I gotcha. Okay. That's
Yeah,
the
Mine came
clarification.
super late because of all the snowstorms, so I just got mine like yesterday. So I'm trying to like catch up with everything now.
Yeah.
All right. I know that if you like Google the cases that are on the syllabus, you'll be able to find summaries. Yes, the cases are in the textbook, but you can find, actually there's a Google Scholar has the actual text of all the cases, but your textbook gives you a much shorter version of what's actually out there. Like, it's not, what you're reading in the textbook is not the entire body of the case. The cases themselves are a lot longer. But I mean, I'm not a fan of having people read like what is that? Back in the day, we had those Cliff Notes. Is that what people use now? Like all those, because it might not give you all the points that you really need. So at least read the specific cases that aren't assigned in your textbook when you do get it. So do we not have to read the topics on chapter 7, like harm to property and defamation? I didn't finish yet. We still have stuff to go, actually. So that was just one topic. So the next thing that we are going to be talking about is specific harm, right? Battery, intentional infliction of harmful or offensive bodily contact. So when we talk about battery in the civil sense, it's actually different than battery in the criminal sense. When we talk about battery in the criminal sense, it's a criminal offense. The burden is beyond all reasonable doubt, and the punishment is, imprisonment of some sort. There's also battery in the civil sense, where the burden is beyond all reasonable by preponderance of the evidence, more likely than not, and then the end game is some kind of financial compensation. Okay, thank you. So that's something to keep in mind. When we talk about intentional touching that could be offensive, it's weird now because I'm actually going to compare it to pre-COVID and post-COVID. Back in the day, before the COVID era had hit, if I was walking in the classroom and I touched somebody on their shoulder, or I coughed or sneezed, people would just say, bless you, and there'd be no issue of it. If now I'm in a classroom and I touch somebody, perhaps they would find it as offensive touching because nobody wants to touch anyone. There's all the social distancing. God forbid I actually sneeze or cough. You're going to think I'm the plague walking, and so that might be extremely offensive. So battery in a civil sense could be considered, or is considered, offensive touching to a reasonable person. Pre-COVID, if I touch somebody like this or tap them on the shoulder, they may find that offensive, but the reasonable person would not. So even if they sued me for battery because I touched them, that's offensive touching to them. They don't want to be touched. The average normal person would not find that offensive. Nowadays, we don't encroach on anybody's space. So perhaps now the reasonable person would find touching on the shoulder offensive. And if I get sued for battery in a civil sense, there may be compensation for that person. Okay, so that's battery. Again, this was kind of listening stuff, not yet writing. Assault could, in a civil sense, is also has a mental component, which is the intentional infliction of apprehension of immediate bodily harm. So if you wanted to play a prank on somebody and you know that they're deathly afraid of snakes or rats or anything like that, and you put it under their chair, you put it in front of them, and then somebody, sees it, they scream, they suffer a heart attack. Well, is that then, assault in a civil sense where there could be monetary compensation? Yeah, if you knew about how much of a fear they had and you did that, you can actually be sued and you could owe a lot of money that way. The next thing I want you to know is false imprisonment. And I'm going to give you an example. Again, it's hard when we're kind of just via Zoom. You don't really get the flavor that I'm trying to share with you, but pretend we were in a classroom, and let's say in this classroom there was only one door, and we're on the first floor on the ground level, and now your class ends at like 9:10, but I love this stuff so much that it's like 9:30, 9:45, and I'm blocking the door so you physically cannot leave the classroom because I just love business law so much. Am I falsely imprisoning you?
Kind of.
No.
Yes. I mean,
No,
Why no?
because that's prison. Prison and a classroom is two different things.
Listen to the fact pattern again. You're on a ground level. I'm blocking the door. Can you get out if you wanted to?
If
yeah.
you really wanted to, sure.
If you really wanted to, you could get out of the window, right? Because I know in CSI, the window, like you can just hop out one leg over the other and you're there. If we were on the 3rd, 4th, 5th floor, then you could say, if I'm preventing you from leaving, there's only one door and I'm preventing you from leaving, and you have no choice but to stay, I am actually imprisoning you. It's not prison, it's a classroom. And yes, I'm teaching and I love it, but I'm holding you against your will. You don't want to be there. You want to go home. Why am I learning about this, right? So it's not so much the physical location, it's about whether or not you're free to leave. Okay? So that is false imprisonment. I block you, you can't leave, and you're being held against your will. The next thing, and this is now stuff I want you to know and kind of write it down, is when we talk about defamation. And when we talk about defamation, I want you to think of defamation as an umbrella. That's how they got OJ the second time. Yes, on a civil case versus criminal. Absolutely right. Because the burden was lower in a civil case as opposed to a criminal. So when we talk about defamation, think about an umbrella like this. And underneath that umbrella is two different branches. One is libel, one is slander. Either way, they have the same elements, just a slightly different definition. When we talk about, I'm going to put this actually in your chat. So when we talk about, that's actually one positive of the Zoom thingy because I have this chat option. I hate writing, like writing things out. So on the board, I never actually wrote anything in the classroom. It was like just more like scribbles. So now I can put it in. You guys can just copy and paste. Everyone, okay. Let's go da 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 da. Okay. So when we talk about defamation, these are the 4 elements in defamation: false and defamatory statement concerning another, an unprivileged publication, basically a communication to a third party, depending on the state, knowing or failing to ascertain the falsity of the statement, and then proof of specific harm. You've heard the words libel and slander before. I'm sure you have in some point
They're
in life.
elements of what again?
I'm sorry?
These elements there of what?
Defamation.
Can you just spell it for me?
Yeah, I'm going to just put it in the chat for you. Defamation.
Thank you.
So when we talk about defamation, and there's 2 different types, there's libel and there's slander. Libel, think of it as printed or written. And slander is spoken or oral. Okay? Hold on one second. So when we talk about libel and slander, people can sue for those things. Why or how? Let's go with how. If they can prove these 4 elements. So if I'm a college professor, I'm also an attorney by day. If one of you decides to spread some rumors about me, and if it is, let's come up with something, that I fail everyone in class and I'm an awful professor. Is it a false and defamatory statement? I'm going to argue it is a false and defamatory statement because it shows that I'm a bad professor. Number 2, is it a publication to a third party? If you just think it to yourself, it's not. But if you start spreading it to other people, you've then made it a communication to a third party. Did you fail to ascertain the falsity of the statement? Did you actually do any research or look into it in any way to see if in fact I do fail every single student? How did you verify the information that you're spreading? Now, again, that's not in every state, that's just in some. And the last one, was there proof of specific harm? Did I lose my job at CSI based on the statements that you just made? Did I lose anything? Did I have any specific harm caused to me? If nothing happened to me as a result of your rumors, I can't sue for defamation. Think about what we had, those 5 elements before, right? The ones about negligence, breach, duty, all that stuff. Damages was also there. If somebody doesn't actually suffer a harm, can't really sue. When also you have people that are in a like higher position, people that are athletes or politicians or in positions of power, the actual defamation burden is a little bit higher because they're held, like everybody's going to talk about people in power because they kind of put themselves out there to the public. So there's actually an extra element in that, but we're not gonna get into that. So that's defamation. So what I do want you to know is the difference, and this is a write it down moment. Write it down. The difference between libel and slander. So again, libel is written or printed. Written, printed, TV, or radio is the full definition, but libel is written, printed, TV, radio, and slander is spoken or oral. So you need to know the difference between those two. Simple enough. Okay? The next thing is, the next concept in this chapter is appropriation. And appropriation is the unauthorized use of another person's name or likeness for somebody's benefit. The case that highlights this concept is White versus Samsung. Who wants to tell us about White versus Samsung?
Wasn't it? So it had to do with Vanna White, the lady from Wheel of Fortune.
Right.
And she had been doing some advertising gigs, and Samsung created what they ended up calling the Vanna White ad. And it was like a robotic personality or something that was clearly meant to mimic Vanna White and the Wheel of Fortune, but they didn't contact her, they didn't ask her for her permission, and she received no benefit from it, and so she sued them.
Exactly. Perfect. So they had, do you all know who Vanna White is?
Yeah, the Wheel of Fortune lady, right?
Yeah. Yeah. I mean, she's the Wheel of Fortune lady. She's been on Wheel of Fortune for like 100 years. And she looks exactly the same today as she did 100 years ago. So that's kudos to her. But yeah, exactly what Jessica said. She, a company, Samsung, made a robot that basically looked like her. They had a wig, they had pearls, and they were standing pointing to something. And I think underneath the ad was longest running game show or something. So they were clearly alluding to her. And so she didn't get any notice. She's famous, so people recognize her. Are people going to automatically assume that she kind of okayed this, that she's behind this? Maybe because she's a loved host, then people would buy this particular product thinking that she endorsed it. And that wasn't the case. If Samsung had offered her money, or if they had paid her, I'm sure she would have been fine with it. But the fact that she did not receive a benefit, financial benefit, she sued. Okay, so that's appropriation. That's the only thing. And sometimes I don't even care really the end result, whether somebody won or lost. I want you to understand the legal concepts behind certain cases. So here, appropriation is when somebody uses somebody else's likeness for their benefit without their permission. Okay, I think that was the last thing I wanted you to know for this chapter. And now we're going to move on to chapter 40, which is intellectual property. Does anybody have any questions about the topics that we just covered? Again, this is recorded, so I am going to post this on YouTube and eventually Blackboard, so you'll see it.
Could you just quickly restate the basic definition of appropriation?
Sure. Appropriation is I'll tell you what I have written down exactly. It's the unauthorized use of another person's name or likeness for one's own benefit.
Thank you.
You're welcome. So now we're going to move on to intellectual property. Intellectual property is a fun, I think it's fun. I mean, I think everything is fun. It is a fun topic. Why? Because I'm actually going to use my little board here, and we're going to start with, this is like not a show and tell, but tell me if you recognize what I'm going to write here. Okay, ready? Boop. What's this? I know I'm not the best artist, but if you saw this on a product, what do you think it is?
Louis Vuitton.
Louis Vuitton. But I didn't write Louis Vuitton. How did you know?
It's iconic.
It's iconic. Excellent. What about this one? This is old school. What is this?
Nike.
Nike. Great. Now it doesn't say Nike anywhere, right? Now this one, here we go. La, 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 la.
Apple.
Thank you very much. And when we talk about Apple, what are we talking about? Am I selling apples?
No, you're talking about
Apple
the company,
products.
the technology company.
That's right. That's right. So all these symbols I just gave you, they are attached to a particular company. Those are logos, right? When you see that particular image, it triggers in your mind that particular product. Companies spend tons and tons of money on brand development. So when they do that, they don't want any other company to steal their logo and put it on their product, right? Because that's not good for their business. So when we talk about trademarking or we talk about intellectual property, intellectual property comes in the form of many different things. So it could be about, symbols, words or designs, logos that are trademarked. It could also be a registration mark. It could be a service mark. I want to also see if you know what these things are. Hold on. If you saw this on a product, actually,
Trademark, right?
thank you very much.
Trademark.
Thank you. What about?
Copyright.
Yep. Those symbols, those tiny symbols, mean that these products are protected by their owner. You can't just use if you went to Michael's and you bought a whole bunch of t-shirts and you started putting LV signs on it or the check mark signs on it, you can't sell those playing off that you are Nike or that you are Louis Vuitton or they're those types of products, because what's going to happen if those companies get wind of it? What are they going to do?
Sue you.
They're going to sue you, exactly, because you don't have permission to use their products. So intellectual property is it could be a design, it could be an idea, it could be a product, it could be a song, it could be a secret formula, it could be a list of customers. It could be a number of things that are inherently owned by a particular company. And so you can't just decide to use it on your own to make money for yourself. When we also talk about these types of intellectual property, we also want to keep in mind something that this is actually something I want you to write down. I'm going to put it in your chat. This is actually really important. When we talk about symbols, like logos, a symbol must be distinctive and not a description of the item. So this is something, again, this is a write it down. I'm actually putting in the chat for you. A symbol has to be distinctive and not a description of the item. Notice that in the three things I gave you, the LV, it didn't, when you saw, it's just two letters put together, right? It didn't say that it's clothes. It didn't say it was luxury. It didn't say anything. It was just what they decided to market as their product's name. The only one that could be a little bit different is the apple. Now, apple is an actual picture of an apple. Hold on. If you wanted to open up an orchard and you wanted to use that picture of that apple on your orchard, would you be able to?
No.
Not
Yes.
unless we get permission.
You can actually. You know why? Because it's a description of the product you're selling. Nobody's going to confuse, right? What is the likelihood of confusion of a consumer if they went to your orchard to buy apples and they saw that Apple sign? Are they going to think that Apple, the company that sells phones and iPads, actually owns this?
No.
No. The court usually asks that question. What is the likelihood of confusion by the consumer? If, however, you decided to have some kind of manufacturing plant where you produced cell phones that were either white, black, or gold, and then you decided to put that Apple sticker on the back of it, and then decided to sell it, can a consumer confuse your product with Apple's?
Yes.
Oh yeah.
Yes.
Yeah.
Yes.
Why? Because it's their space. They're known for electronic material, right? So the question is there a likelihood of confusion? And is the symbol, when we talk about logos, is the symbol that it's being used distinctive or is it a description of the item? If it's simply a description of the item, you're not going to be able to patent it. You're not going to be able to get a trademark on it. You're not going to be able to get that seal of approval from the USPTO because it's simply a description. It doesn't do anything. It's not unique to your particular company. When we also talk about intellectual property, you also want to keep in mind that companies can actually lose their trade symbols like that patent, that ownership, if the product becomes generically used in society. So how many people here have actually used Tupperware? Give me a show of hands. How many people here use Tupperware? So I see a bunch of hands that go up. Is it the actual brand Tupperware?
Probably
Or
not.
is it like a plastic container with a tightly fit lid?
Definitely knockoff.
Definitely, yeah, exactly.
Yeah.
So,
Like
but when
pizza-
I say the word Tupperware, you're thinking, because people in our society, in our community, have used the word Tupperware, it's become actually generic. I didn't know that Tupperware was an actual brand until, later in life. When somebody was trying to sell that particular brand, I was like, oh, I thought Tupperware was just like, plastic stuff. It's an actual company. And so people started using that name left and right. And so it becomes diluted. It's no longer meaningful. So why are you going to spend $100 on a plastic container set from them when you can spend $10, $15 and get it from, Walmart or something, right? What about, and this is actually a true story. My mother-in-law, when I first met her, she would always be like, oh, can you hand me a Kleenex? I'm like, I don't have Kleenex. I have like tissues. Like Kleenex, right? Band-Aid. Yes. Kleenex is the same thing. There's an actual brand called Kleenex. But do I have that product at hand? I have tissues. It's the same, it's different, but it becomes, generic. Xerox. Somebody had mentioned to me before Windex, that their mom refers to any glass cleaner as Windex. It's not. Windex is an actual brand, but people start using it and then it becomes kind of known for that. So if you start using a particular product's name and throwing it around, see, oh, lip balm and chapstick. Yes. That's right. I actually use chapstick all the time. Like I say, oh, do you have chapstick? That's the word I use for something to moisturize the lips and not chap them in the wintertime. So that actually dilutes the brand's name. Some people argue, well, isn't that good for the brand itself because it makes, it's like free advertising? Again, it comes down to the consumer. It comes down to the consumer. Are they going to pay this much money for this particular brand that spent all this time, educating consumers and blah, blah, blah? Or are they going to spend this much money on something that does a similar thing, right? Somebody wrote about burgers and Burger King and McDonald's. Yeah. So yes.
Sorry to cut you off.
No, go ahead.
So all this falls under a symbol has to be distinctive and not a description of the item, correct?
Correct. For the logos and stuff like that. Yeah.
Thank you.
You're welcome. So that actually takes care of everything I want you to know for intellectual property. Trade symbols. Okay. Okay. Oh, I want to also tell you about patents a little bit. If you have a great idea, you want to patent it, right? Because patenting it allows you to safeguard that idea and make money off of it in the future. But to patent an idea, anybody here watch Shark Tank? Anybody ever watch Shark Tank?
I've seen
Yes.
clips.
Yeah, I did.
Okay.
Best.
So with Shark Tank, sometimes the question is asked when they have this wonderful, brilliant idea, is it patented? And so sometimes they say it's pending patent approval, it's, it's not, or it is. When a product is patented, it means that other knockoffs can't spring up and actually copy their idea, because then you can go after them because you own the idea. There's something that I want to say I learned about it in law school, and it's called the poor man's patent. So let's say you have a brilliant idea and you want to show that you want to be able to prove at some point when you came up with this idea. What date did you come up with it? So when you write, if it's like a product or something and you have the prototype and you have whatever information you have on it, what you want to do is you want to put it in a sealed envelope. Again, I don't know if this is actually going to like hold water if it ever comes to a lawsuit, but you want to put it in a sealed envelope and you want to mail it to yourself. When you get it back, you do not open that letter, but that letter is going to have a postal mark on it. And on that postal mark, it has a date. So if it ever comes to a particular, lawsuit or whatnot, you can prove that that's when you had that idea because it's a sealed envelope with that date on it. Hold on one second. Hold on. My life is torture. So that's the poor man's patent. So kind of just keep that in mind if you ever have a brilliant idea. But you should, if it's a really good idea and you're going to submit it for approval and it gets approved, I mean that actually gives you a lot of obviously opportunity to make money. When you talk about, again, this might also like now ring bells. When we talk about medicine, right? There are brand name products and there's also generic products. I worked in a pharmacy for 7 years. And we used to always tell the consumers the generic is just like the brand, maybe the inactive ingredients may be a little bit different. When you have a product, a medicine that just comes out brand new, there's always a patent on it because a company had spent so much time and money researching, so they get approval for a certain period of time where they can make money. And then after that, I think it's more for, societal health reasons. Then it gets no longer the patent is there. It's for a certain period of time, and then other people can make it. I don't think that exists for every other product, right? A lot of products you have a patent on it and it's basically for life. It's not going to expire after a certain period of time. But with medicine, I think it's because it has like the ultimate good for society. Then it's for a certain period of time, and then other companies can make it. So that's just as an FYI. I'm going to move on to the next chapter, which is accountants' legal liability. And accountants, I know a bunch of people in this class, I believe, are accountant majors or math majors. Some people think that, being an accountant is very safe. You're not going to get sued. Accountants can get sued. If you're an accountant, how do you think you could get sued?
Intentionally,
Say that again.
like when you intentionally like cook the books or something, right?
Intentionally, yeah. Like if you mess up numbers intentionally, absolutely. What else? How else? Let's say it wasn't intentional, but how else? Fraud. Yep, absolutely. How else?
Like if
Anything?
you royally fuck up and it like results in somebody like a client getting screwed over in the process.
Absolutely. I wouldn't have put it in those exact words, but yes. So if you mess up somebody's evaluation, a company hires you to assess something, and you come up with a particular number assessment, and so other third parties now are basing their business strategies on that, and it's wrong, you can get sued. It's negligence.
You
It's essentially negligence, huh?
you lost $500 million on this terrible deal
Yep.
because you this.
Yeah.
Yeah.
Yeah, exactly. So when we talk about accountants, there's certainly a lot of liability that exists. So it could be liability to foreseen users, the person that hired you, but anybody also that relied on you. They can also sue you for the damages that they incurred as a result of justifiably relying on your representation or lack thereof. And obviously, like fraud and things like that, that's a big one. And that's actually all the stuff that I want you to know for accountants' legal liability. Any questions before I move on? Okay, I'm looking here. I just want to make sure. Okay, so the next chapter is the longest one, chapter 8. So that's going to be the chapter that we do, and then we're going to leave off chapter 47 for next week. Also, please, just as a friendly reminder, also take a look at your syllabus. Your first exam is February 24th. It's in 2 weeks. So it comes up quick. It creeps up on you. So just kind of keep that in mind. So I'm going to move on to chapter 8. So chapter 8, we go back to negligence. And now when we talk about negligence, we're talking about just a little bit more detail than what I had spoken about earlier. We're going to talk about more cases that highlight those legal theories. There are some areas in negligence, like strict liability, where they're not really based on the negligence or the intent of one person, but on the activity itself. Meaning, if you commit this activity, you're screwed. Like, so if you sell alcohol to a minor, you can't say, I didn't know that they were a minor. Like, that's not good enough. You're going to get fined. The other one, and it's actually a little bit more criminal, it's statutory rape. You can't say, I didn't know his or her age. If they're under the age and you commit that act, it's based on, so statutory liability, it's based on, strict liability, it's based on the act itself and not on the intent of the person. So that's just an FYI.
Then
yeah.
like what would happen if like you sold alcohol to a minor, but they showed you an ID and it was like a really good fake ID?
Doesn't matter. You're going to get fined as the seller. So, and it's a shame, like, but that's just, yeah, too bad for you, basically. So because it's meant to tell those owners, those sellers, to be extra careful. You got to be extra careful, like because they don't want alcohol being sold to minors. Okay, so now we're going to go back to negligence, and we're going to talk about those 5 elements that I mentioned earlier. And now we're going to talk a little bit more detail into each one. So when we talk about duty, I spoke about the duty that one person owes to the other. Now, in courts, usually you're compared to somebody, right? So it's one person owing a duty to another. Who do you get compared to see if you kind of messed up or not, if you did what you're supposed to do? You get compared to the reasonable person. So there's this thing called the reasonable person standard. This is something I want you to know. So you need to kind of listen, understand it. It's in your textbook, it's in your material, but I'm going to go over it because there's actually different designations of the reasonable person. So when we talk about the reasonable person standard, the reasonable person is a perfect person. That's really if you want to like define it, reasonable person equals perfect person. It's a person that's always prudent, always knows what they're doing, always follows the law, doesn't do anything wrong, and it is careful, never negligent. It's the person that drives at 10 and 2 at all times, looks both ways before crossing the street, belts and suspenders type of person. Okay, that's the reasonable person. That's who you get compared to. Now, there's different types of cases where the reasonable person, I feel like they're going to kill each other. There's certain types of classifications based on situations. So the first one we're going to talk about is if you commit an act and the person who's being sued is a minor. I'm going to sue my own kids one day. You're going to see that. That's going to make headlines for traumatic and stress, because I'm stressed beyond belief here. When you have a minor, hold on. Children, they get compared to equally perfect children. Okay, so if you have a child who has the age of 14 thrown a baseball and broke somebody's window, they're going to be compared to a perfect 14-year-old. Would that perfect 14-year-old have thrown a ball and hit their neighbor's window? Would they have bit their brother? Would they have been hiding in a closet and knocking things down and causing damage? You compare it to a perfect child. So anybody under the age of 18, if they're being sued for something goes wrong, they get compared to somebody that age, but perfect. The only difference is when that child is engaging in adult behavior. So if a child, 12-year-old, 11 years old, commits a crime, kills somebody, drives and hits somebody, they're not going to be compared to, chances are, they're not going to be compared to somebody that age. They're going to be compared to an adult. And the reason for that is they're engaging in adult behavior. So they're going to be compared to an adult. Okay, so far we talked about the regular perfect person, regular reasonable person. We talked about the reasonable person standard when it comes to minors. The next one we're going to talk about is persons with physical disabilities. So if I am crossing the street and I didn't go all the way to the crossing area, and I have an injury on my leg. My left leg is in a cast. I'm crossing the street. I didn't see any cars. I just wanted to make it to the other side. That way I don't have to go all the way to the crosswalk, cross, and then make it back. A car is actually speeding and they hit me. So we collide into one another. I sustain further injuries. Who am I going to be compared to in this case?
A reasonable disabled person, someone
Yeah.
who is like injured or has a disability and knows to be extra careful about
Exactly.
crossing the road or something
Exactly.
like that.
Exactly. I would be compared to a perfect person who's suffering that same physical disability. Same physical disability. Now, what happens when you have a person who's being sued or being sued, and they're suffering from a mental disability?
They probably have trouble, thinking or, thinking straight. So they will be compared to someone with, I don't know if they'll be compared to, no, I don't think so. I don't know.
That becomes like a lot more complicated because like
Yeah.
there's no like one set like
Because
mental
it
disability.
throws in a lot of questions. It's not like you can compare that person with the same mental disability. I don't know.
It
I will
doesn't
tell
count.
you, this is the trick one. This is the one that's different than all the rest.
Wait, can you repeat it? Can you repeat it again?
Sure. If somebody's being sued, right? So they're in a car accident. So let's say instead of the physical disability that I was crossing the street,
It's
I
a
had a
mental
mental
disability.
disability,
Okay.
and I was crossing the street. Who would I be compared to?
To a normal person.
I'd be compared to a normal person, somebody without any mental disability. So somebody who suffers a mental disability, they get compared to that perfect person I spoke about in the beginning, the one that's the perfect person, the 10 and 2 belts and suspenders.
But wait, so if a physically disabled person, gets into an accident, they'll be compared to another physically disabled person. But if a mental uh person, a mentally challenged person gets into an accident, they'll be compared to a regular person, like
Yep. The perfect person, the reasonable person. Yep.
But how though? That doesn't make sense.
It doesn't make sense because mental
If
disability.
anything, mental is worse because like that's you think, I'm sorry to cut you off. Go ahead.
That's okay. So it's the reason is our society has not yet caught up or understood or takes into consideration people with mental disabilities. I will tell you from personal experience, I work right now with people who I work in the guardianship department, and so I deal with a large number of people who are petitioning for guardianship of persons with disabilities, mental disabilities. And the statute, the law that we follow, up until just a couple of years ago, it used to define that section of the law was called mentally retarded. That's how people were still looked at, mentally retarded. It wasn't that long ago. I think it was like the 1940s, 1960s. I don't know if you're familiar with Staten Island and the Willowbrook era.
Yeah.
Okay. So that's actually like part of it is a CSI. And so people with mental disabilities were just kind of thrown in really abhorrent, awful conditions.
They were treated horribly.
Yeah.
It
And
is
so, exactly. And so the law still has not yet caught up with people with mental disabilities and how they should be treated.
So
Because
after,
who's fighting for them, right? It has to be their family members or somebody else. It's not something that's really like a broadcast out there. So until that changes, the only thing maybe in like a criminal sense, if somebody commits a crime somehow and they are, sometimes we have like the insanity plea. So when we have a crime and somebody wants to get out of it, it's like guilty, not guilty, or I claim self-defense or I claim insanity. So you're saying I'm crazy. It's different than having a mental disability, saying I'm crazy, because when you're saying I'm insane, I don't know what I'm doing, it's still a negative connotation as just recognizing that somebody is under a mental disability. But that's actually a way where they don't have to be put, quote unquote, into prison. It would be just, a mental facility where they could be treated. But again, the whole outlook on, this area of the law is still not clear. So persons with mental disabilities are treated as a regular, reasonable person. Okay. So that's your fourth designation. Your last designation has to do with somebody who is a professional, has a professional skill. So a doctor in the ER in New York City cuts off the wrong leg, amputates the wrong leg. And you know what? I actually worked in a PI firm in the city where that was a case. Who are they going to be compared to?
The
Perfect
perfect doctor.
doctor.
Perfect doctor. But the doctor also has to be in the same type of work, like also an ER doctor, also like in the city, something like that. You're not going to compare a doctor who does trauma in, New York City to a doctor who, does dermatology in Nebraska somewhere. Okay.
the
So
perfect surgeon in New
I'm
York
sorry.
City.
I'm sorry.
So the perfect surgeon in New York City.
Yep, exactly. Based under that same level of stress, same environment, things like that. So you want to compare apples and apples, essentially. So, but it'll be but you're comparing them with another doctor. You're not comparing them with a lawyer or a regular layperson. It's somebody with that same special skill set. So that's the reasonable person standard and all its designations. Okay. Let's see here. Okay, so the next case. Oh, also I have this note here. When a person becomes voluntarily intoxicated, that is not an excuse to whatever the wrong behavior that they get sued for. So you become intoxicated voluntarily and you enter into some kind of contract or you do something that you're not supposed to be doing. That is not an excuse. You got wasted. That's not the court's problem. You're going to get sued and you're going to lose. Okay, next case I want to go over is Ryan versus Fryzen Han. Who would like to tell us about Ryan versus Fryzen Han?
So this had to do with Todd Fryzen Han. I believe he was a minor as well. He threw a house party. He said, "Bring your own beer." Girl comes to the party. Sarah Ryan, she gets completely drunk, goes home intoxicated, and gets into a fatal car accident and dies. Her parents sue Todd's parents because they believe that they knew of Sarah's condition as well as knowing that the party was going on. I believe they also sued some of the alcohol suppliers in the area.
Excellent,
So,
very good. Now, in this particular case, they actually sued and I don't know, I think it was like reversed a couple of times, but don't even worry about that. This case wants to teach you that when it's a minor engaging in, strike that. If a parent or an adult was having a party and other adults came to the home and they got drunk and they left, you can't control what other adults do, right? That's on them. But when you have minors, a parent or an adult is supposed to be able to control the actions of minors. So the reason, ultimately in this case, Todd's parents were found liable because they should have known what their kid was up to and what was going on in their house. That's their responsibility. It's not like they were above the age of 18 and they, they could engage in adult-like behavior. These were minors engaging in adult-like behavior,
Uh,
and the parents should have known about that. Yes, sir.
So that means I didn't read the case because I didn't get the book yet. But so doesn't that mean that so how were they able to sue the other family or the suppliers if it
For
was their
negligence.
fault basically?
Because the parents are supposed to be responsible for their children. They're supposed to
Exactly.
be watching them. They're supposed
Yeah.
to be,
I understand that, but exactly. So how would the parents sue other people? Like, do you understand my
Well,
question?
I'm
If-
trying to. Is it
if
like the parents of the dead girl? They're suing the host because they trusted that their daughter was going to another child's house, also a minor, so that the parents would be there. There'd be control. Hold on. So it's on them. It's on the parents, the host parents, to know what's going on with their kids. So that's why they were sued. Because they should have been able to control the situation. They should have been able to safeguard. And again, I believe this was in Texas, and they have a law there
Oh,
that
I
says,
thought you meant that the girl that got into the accident. I thought you meant it was her parents' fault.
no, it's not her. No, it was her parents are the ones that sued the boy's parents.
Yeah, that's where I got confused because I thought you
Gotcha.
said it was her parents' fault, but it's the boy's parents' fault
Correct.
because they should have been aware of what he was doing and
Exactly.
this and that. Okay.
They're the host of that house. Yes, exactly. So that's
Does the age of liability end, by the way, like for
18.
18? Okay.
Yeah. Yeah. Some places it could be 21, but you're considered an adult at the age of 18. So again, here you even have alcohol. So, you're not supposed to drink alcohol until 21. So would that have made a difference? But an adult is considered an adult at the age of 18. A child is considered an adult at the age of 18. Okay. All right, let's see here. Okay. So again, back to duty, and I kind of mentioned this earlier, but I'm going to run through it again just a little bit. So there are certain duties that one person holds to the other. And so you have like a general duty for the safety of people around you, but not when somebody is under some kind of risk that's created by a third party. But when we talk about, like, I as a parent have a duty to safeguard my kids. So I keep looking at them to make sure they're alive while we do this, right? So that's my duty as a parent until my kids turn the age of 18. I'm still responsible for them. As a teacher to young children under the age of 18, there is a duty. I mentioned also common carriers with passengers, and that means bus drivers, train drivers, things like that. They have a duty to the people on their bus, train, whatever, to make sure that they're also safe. Employer with employees, landlords with tenants with respect to common areas. They have a duty to make sure that all that stuff is in, good control, or that there's no danger posed to other people. The case of Soldano versus O'Daniels also talks about that special relationship when that one of the ones that we just spoke about. So who wants to tell us about Soldano versus O'Daniels? It highlights the duty principle or the special relationships.
I could talk about it.
Hold on. I want to see if anybody else has read.
Can you hear me?
Yeah, David?
Yes.
Go ahead.
All right. Someone got shot, and the bartender refused to call for help or get involved in any which way. And it was such a minuscule duty that the bartender prevented from any help happening that it became the case.
Excellent. Exactly it. It was, so a person got hurt. Another person went to get help, and they were like, just let me use the phone. Let me just use the phone. And the person who had the phone, they were like, no, they didn't want to get involved. But the court said, it's such a minuscule act. You didn't cause the harm. You weren't going to do anything, but you prevented somebody from using the phone to get help. And so that is a no-no. it's such a minuscule thing where the end result, you could have saved somebody's life, that you shouldn't do that, especially when it's a common carrier, an innkeeper, a facility that's open to other people. If that person had ran and gone to a private residence, there may have been a different outcome, because a private residence does not owe a duty to help people like in the streets, right? It might have been that because it was an open facility, open to the public, then they had a duty at least to give somebody that phone. Good. I've noticed it's only a
Also,
couple of
wasn't
people.
there- I'm sorry.
Go ahead.
Also, wasn't there, it was because they were at a separate location and then the guy ran to a completely different restaurant to ask for help. So
Yeah, he
wasn't
went like
that-
across the street to get for help.
Yeah.
And the place that he went to was also like an open establishment, open to consumers. So it was, again, so minuscule on their part to just let them use the phone. But what I was saying before is there's only like 2 or 3 people that have volunteered to talk about cases. There's in this class right now, there's 43 people. I expect everybody to read. This is the least you can do. You're only helping yourself, because just as an FYI, the exams, it's not like, what's the outcome of this case, or like I ask questions that you need to have read the case or understand it in order to be able to make analytical analysis of the questions I'm asking, because I'm liking it to different things. So just kind of keep that in mind. If you read, you're only helping yourself. Don't wait until the day before the exam. I know the exam is open book, but don't wait until the minute before the exam. Okay, so right now it's already 7:42. I'm going to give you the secret phrase for tonight. So for February 10th, this is for attendance purposes. So the secret phrase for tonight is, let me write it down also, that way I do not forget. It is, Simon finally got a haircut. Simon finally got a haircut. One more time, the secret phrase for tonight for attendance purposes, it is Simon finally got a haircut. Do not post that in the chat. Do not post that in the chat. One more time for attendance purposes for tonight, Simon finally got a haircut. So this would be number 2 for you. Last week I just took attendance, so this would have been your second attendance grade for the class. 8 more, and you get 100 as 10% of your grade.
Professor,
Yes.
I'm sorry, but
That's
I
okay.
wasn't here last week, so that's okay for me. If it's like,
Why don't you email me later? Because I took
Okay.
attendance, I didn't give a secret phrase last time.
oh, okay, so
Professor,
Yes.
so we must read the cases in order to do good on the exams. Like
You
that.
must read the stuff that's on the syllabus to do well, but especially the cases.
Yeah, okay. Because it's been like I don't want to get the textbook on the computer on the laptop, because like I'd rather get the physical copy, but I can't find any physical copies
I'm sure you
online.
can find it on Amazon. It's available on Amazon. It's available at your CSI, because we post, the professors post, or we notify the school, a month ahead of when classes start as to the book. And so now we're on our 2nd week of classes. So there's really no reason why so many of you don't have the book unless you ordered it really late. So Amazon or wherever you're getting it from. Even if, I don't care if it doesn't have to be the newest book, by the way. Order like the 10th version or the 11th. It doesn't matter. I don't care what edition you get. If it's cheaper, you can just get it. Oh, so somebody wrote Chegg has it. I don't know what that is, but look into Chegg. Okay, I'm going to move on. Okay, there are certain duties now. We're going to move on to a little bit of trespassing and a little bit of land. This is a listening, not a writing. So depending on the type of land that you have, you can have somebody trespassing, which basically means, and you've heard this term before, somebody that's not supposed to be on your land. But if something goes wrong while they're trespassing on your land, then they usually cannot recover. However, when you have a public area, the people that come into your public area are designated as something called invitees. So you have a duty to make sure that the areas are clean, free from peril, and that anybody that comes onto your land is not going to have a problem and end up suing you. So like slip and fall on ice. If you're inviting people, you have to make sure that at least that part's okay, because if they come onto your land, your store, things of that sort, they slip and fall, then you're going to be sued. And then licensee is a type of designation where if you're just having people over your house, they're called licensee. You're not like a store, you're not a park, you're not a museum, but you are aware that people are coming to visit you. And so you also have an obligation to make sure that the streets are cleaned, salted, there's no ice, there's no cracks or anything like that, because if they fall and hurt themselves, then you can also be sued. Okay, the next thing I'm going to go over is next case. This is a good case, and I usually test on something to do with this case. This is Love versus Hardee's Food System. Love versus Hardee's Food System. Anyone?
I'm not sure I have all the facts, but someone went to the restroom in a restaurant and he fell and
Right.
broke something.
Good. Do you remember what else happened?
No, I don't.
Okay. So it's a slip and fall in a restaurant, in a bathroom, the bathroom in the restaurant. Anybody else want to add anything?
Wasn't it because he was saying there wasn't proper notice of water being on the floor?
Correct. So there was a slip and fall, and the owners of the restaurant were supposed to have like this log. They had the person that was the employees are supposed to go in there and clean the water and fill it out. The restaurant wasn't particularly busy at that moment in time, so there was really no reason why nobody had checked the bathroom and kind of cleaned it up. And so this person was able to recover money for their injuries because the water was there for quite some time and it wasn't cleaned up, even though as part of the restaurant rules or protocol, somebody was supposed to go in every period of time, X amount of time, and kind of check on the bathroom, and nobody did that. And again, facts are important because the store wasn't busy. The water had been there for a long time. There was supposed to be a log, and actually when it came to evidence, I think like that log was missing. So it's on the owner of the restaurant, who is an invitee. They're inviting customers into their place to make sure that all conditions are proper. So if you were going to ShopRite or Stop and Shop or any of those stores, and the customer right in front of you, like 2 minutes ahead, had caused a jar of sauce to fall and slip all over the floor, and you slipped on it and fell, would you be able to recover money?
This actually happened recently at the shop that I work at on Forest Avenue. I work in I'm basically a janitor, and someone like dropped a tomato on the floor and like it got like stepped on, and like it left a spot, and no one called the janitor to clean it up. So someone fell, and apparently we might get sued. But
How long was the tomato there?
the story I was told was that the produce dude saw it. Instead of calling maintenance, he put a wet floor sign. He went to the back to get paper towel, and then a customer moved the sign. And by the time he came back, someone slipped and fell.
It's actually not enough time for a lawsuit because there has to be a reasonable period of time. And what the person actually did, they put up a thing, and this is free advice for ShopRite because that's where I shop, so it's all good. So they put up a sign. They put customers on notice that there was an incident there was a problem there. So they put them on notice, hey, beware, there's a problem here. They went to get the towels and they came back. It's not a reasonable period of time. It's not like it was there for an hour. It's not like it was, right? Don't even tell me. I don't want to know.
I know. I have no idea how long it was there.
Yeah. So if it was there for an hour, 2 hours, then you would have had to have that responsibility. But an incident happened. Somebody went to get, the material necessary to come and clean it up, and they put that thing there. That's not a reasonable period of time for a store to kind of clean it up. So the example was actually I was giving, if the customer right in front of you dropped something and you fell, you're probably not going to be able to recover because the store did not have notice and they did not have the opportunity to clean it up. So keep that in mind, but they have lawyers, so I'm sure they'll know that. Hold on, let's see, blah, 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 permanent damage. Then wouldn't having a log be a bad thing for a company? It can be used for proof of negligence, but it could also be proof that it was just cleaned up and that there wasn't enough time for them, that they were not negligent. Because if they had the log and they showed, 1 o'clock they cleaned up, 2 o'clock they cleaned up, 3 o'clock they cleaned up, and this happened at 3:05, but the next time they were going to check again was 4 o'clock, it shows that they were in compliance. They did everything that they were supposed to do. So it could be used both ways. Okay, so that was Love versus Hardy's. This is a fun thing. This is something like if you want to be cool in front of your friends and talk Latin, like legal Latin, the phrase res ipsa loquitur, it means the thing speaks for itself. It's kind of like it is what it is, like what you see is what you get. There's no other way to explain it. I'm going to put that in your chat because I think it's fun. So you could be like, oh, we learned about res ipsa loquitur today, and just throw it out there. People think you're cool. Nobody's going to think you're cool. Okay. Next thing concept we're going to talk about is that causation, which is the actual cause and the proximate cause. And I told you that, actual cause is pretty easy. It's the conduct that actually caused the harm, right? It's the actual thing happening that caused the harm. But when we talk about proximate cause, that's what is a little bit more difficult to grasp. But the case of Palsgraf versus Long Island Railroad really brings that concept home, really explains it very well. And this is a case that's actually taught in law schools all around the country when it comes to the legal concept of proximate cause. So who wants to tell us about Palsgraf versus Long Island Railroad?
Can you hear me?
I can hear you.
If I can remember, wasn't it about how Palsgraf, she was waiting for a train? All 2 other men were trying to chase another train, and one of the men, his package fell on the rail, and then there was firework in it, and it exploded, and then the platform fell, and then she got injured, so she sued.
Excellent, excellent. But I'm going to even make it more dramatic. You hit it all the points, right? But let me just make it more dramatic. Mrs. Palsgraf, poor Mrs. Palsgraf, she's waiting for the train on one side of the railroad. On the other side of the railroad, these 2 guys are running, trying to get onto their train, going in the opposite direction. Some of the employees, before the door closes, they push these guys so they can get onto the train. But one of them is holding this package of fireworks, because who doesn't carry fireworks onto the train station, right? The fireworks drop, they explode, they cause a scale on the other side of the train station to fall and hit poor Mrs. Palsgraf. So she sues the train company. The question becomes, was it foreseeable that as a result of these guys trying to get on the train, that their package of fireworks would explode and cause a ricochet reaction that would get her injured? If I had started to just tell you a woman was on the train and on the other side of the train, 2 gentlemen were trying to get on the train, would you have ever, in your wildest dreams, thought that that's how the story ended? Anyone? Is that what you have thought? Allie, thank you for indulging me and shaking your head no. No, you would have never thought that, right? Nobody would have thought that that's what the outcome of that case was. So it wasn't foreseeable. So proximate cause is like a foreseeability factor. Was it foreseeable that as a result of X, Y, and Z, A, B, and C happened? And if it wasn't foreseeable, then the party who's being sued is not going to be found at fault. It's like, you're driving on the expressway, you hit the car in front of you, yet somehow that car hits another car who stops a pedestrian, who does something at the other, like, it's so crazy and far-fetched. If it's not foreseeable, it's not proximate cause. But if the end result is foreseeable, yeah, you can see if that happened, then damages will be incurred and a cause of action is there. So I know the concept is a foreign concept. Think of it as foreseeability. But for this, would you have imagined that? A little clearer? Not so much? Anyone? Talk to me.
No, that makes sense to me.
Oh, okay, good. Great.
Like that totally, like, that registers with me.
Okay, good. Good.
Yeah, is it like a no fault case and like even in a car accident and stuff? Sometimes insurance plays.
Well, like no fault, it's kind of like you're, I think no fault is even like a simpler concept to understand. Like the proximate cause is like, I just think about it as like foreseeability. Like with no fault, it's like, okay, it happened on the job, you'll get something for it. This is more of, is that person going to be found liable based on the circumstances because the injury that happened is foreseeable based on the conduct of the defendants? Something like that. I don't know if I made it better or worse. Sorry. All right.
A freak accident.
Huh? Yeah, a freak accident. So if you have a freak accident, there's no proximate cause. And so there's not a likelihood of recovery because it's a freak. That's a perfect way to put it, actually. So crazy that it's no. But if it's not so crazy and you could foresee these injuries or this situation happening, then you'll be able to collect. But if it's a freak accident, chances are you're not going to be able to collect. Perfect. I'm going to use that from now on. Thank you.
I think she was awarded money though, from
She
what
was
I'm reading.
But I think, she sued the train station, but she lost against the train station. She should have sued the people themselves, the people that were carrying the fireworks, right? So that's another thing. And this is not something I test on, but this is like an FYI for life. So you always want to sue everyone. You want to sue them. Anyone that had anything to do with your incident, you sue them all, and then you work out the details, and then you can let people go. But if you sue the wrong party, or you sue one party and then they're not found liable, you're going to be screwed, right? You're going to be out of luck.
All your eggs in one basket kind of situation.
Huh?
All your eggs in one basket sort of situation.
Exactly. Why? Because don't forget, and don't talk about this really in this class, there's usually a time limit that you can sue on. So
Statute of limitation.
That's right, statute of limitations. So you only have a particular window of time to sue. So if you've spent all this time suing this one entity and then they're found to not have been liable, the time period may have run out on you suing any other third parties. That's why, and again, I don't recommend this anymore because now I'm married to a doctor and I see what they go through. But like when a doctor gets sued, it's the doctor, it's the hospital, it's the nurses, it's anyone that walked into that room or had anything to do with that patient. They sue everyone, and then it kind of like things work themselves out. Was there negligence? Was there, misdoing? Was it, how extreme was it, and things of that sort. So FYI, sue everyone. In conclusion, sue all. You can't go wrong if you sue everyone. Okay, so now we talked a lot about the duties and all that stuff and suing people. Now we're going to talk about defenses to lawsuits, defenses to negligence actions. When we talk about defenses, it's kind of a little bit similar, but not so much to criminal law. In that case, that fake example that I gave you, where I was crossing the street and I had a broken leg and I got hit by a car, but I was crossing in the middle of the street. I wasn't crossing in the crosswalk. Let's say I was able to recover. The jury awarded $100,000, but they found that I was 40% at fault because I was crossing in the middle of the street as opposed to the crosswalk. So if the jury awards $100,000 and I'm 40% at fault, how much am I going to recover?
60 grand.
60 grand. That's comparative negligence. They compare, they do an analysis of who was wrong by how much, and then you get kind of the difference. There are some states where if you're the person suing and the jury finds that you are more than 50% at fault, you get nothing. Now, don't forget, you as the plaintiff, you have to show more likely than not that there was a duty breach, actual cause, proximate cause, and damages. So in that case where I say that I'm crossing the street, right? Was there a duty by the driver to not speed? Yes. Did he breach that duty by speeding? Yes. Was there actual cause? Yeah, I got hit by that car. Yes. Proximate cause. Proximate cause. Had he not been speeding, would I have gotten hurt? Yeah. Had I been walking in the crosswalk, had I been hurt? I don't know. So that's like a maybe. Were there damages? Yeah, I got hurt. I broke my other leg, so now I have no legs. So in that situation, the jury can very foreseeable see that there was $100,000 worth of damages, but because I also took part in that fault, it was also maybe my fault because I wasn't crossing in the right direction, then I could also not be awarded those full damages. Okay, so that's just comparative negligence, just the theory that you should know. There's also a defense is assumption of risk. Assumption of risk is if you engage in dangerous behavior, then the risk is on you. Any problems that happen are going to be your fault. So if anybody here has ever gone skydiving, anybody here go skydiving? Somebody, you were actually raising your hand. Julia, so now I'm going to put you on the spot. So Julia, when you went skydiving, crazy person that you are, did you have to sign or write or fill out anything?
I did, because
what did you fill out?
It was like a consent where like they said, kind of like, if I could put it in simple, if I like fall off, they don't have any right, kind of, you can't really sue them for anything, because I kind of signed my name saying that it's totally fine if I fall or not. It's not on you guys.
Did you actually read the entire thing?
No, it was a lot of pages.
Yeah. So most people don't actually read that. They just sign. It actually says if you die, not only can you not sue because you're dead, but all your heirs and your estate can also, they can't sue, because you're basically signing a waiver saying, I'm engaging in dangerous, crazy behavior. And if I get injured, if I die, nobody's fault but mine. And people still do it, right? So that is an activity where you're assuming the risk. People who fight like wild animals for fun or engage in the extreme sports, they're signing these waivers where they're saying, if anything happens to me, it's okay. Why? I'm okay with it. And so I'm not going to sue anybody or anything like that.
Well, I'm going to throw myself 10,000 feet in the air all the way down to the ground. So,
Yeah, exactly. So if I'm crazy enough to do that, then it's all right. I'm okay with that because I want to get that adrenaline rush, but I'm not going to sue. So when you're engaging in those types of behavior, you're assuming the risk. And so that's actually a defense to lawsuits. Okay, the last case we are going to talk about is Palumbo versus Newkirk. So who wants to tell us about that one? And that's the last case for the evening. Okay. Anybody besides Jessica?
Mailman bit by an animal, delivering notice.
Yeah, that's it. Mailman was bit by a dog. He sued the owners of the dog. So this is now a piece of information for all the people with animals or who are going to get bit by animals in the future. My kids are biting each other right now. It's like I have animals. You only get one chance. You only get one chance. So if you have a dog and that dog bites another, that dog bites another person, the liability is not going to be incurred. My 3-year-old wants more coffee because that's how we roll here. If There's no more. It's finished. Just give me 5 minutes, child. If you have a dog, this is my life. It's torture. Don't laugh. I see you, Carmine. You're laughing. You're going hysterical. I'm dying here.
I thought I was
This is
muted.
not this is not professional by any means whatsoever. You get one bite. So the whole purpose of the law is notice. So if the owners know that their dog bites people, and there's a history of that, then they're going to be actually liable for any injuries or damages that dog causes. But if it's the first time, there's no way for the owners to have been put on notice that their animal has some kind of violent tendencies. So in this particular case, it was the first time that the dog had bit another person, so there was no liability incurred. The mail carrier did not recover anything because it was the first time. But now that family's put on notice, so if their dog bites somebody else, then that person sues, then they'll be able to recover money. So that is the case of Palumbo versus Newkirk. Okay, the last thing I'm gonna leave you with, so that's kind of like with animals that are domesticated. So that's dogs, cats, I guess rabbits or whatnot. It's different if you, oh my God, if that's different if you own a wild animal. So there are some people that own tigers or snakes or things of that sort. You having a dangerous animal, you don't get that like first bite rule, if you call it. Anything that you have that you any bite or any injury that your animal actually causes to another person, you're going to be automatically liable because you have a wild animal in your presence. I hate you here. Okay, that concludes class. If anybody has any questions, I'd appreciate it if you email me and we can set up a time when they're both in school and we can actually talk like human beings.
Have a good day, Professor.
I appreciate it. Thank
Good
you all. Have a great night.
Have a good
Have a good
night.
night.
Have a good night.
Have a good night.
Good night, all.
Good night, Professor.